our session is really going to be about peer review and hospital medical staff privileges and how to navigate that whole space as more and more physicians become employed under different sorts of whether it's healthcare systems to different institutions. This process, this privileging process, the peer review process becomes more and more important because now it's no longer the physician operating in their own practice, individual practice, and as they're being overlooked by the licensing board. Now they're inside institutions because that's the way the trend is going, and they have to comply by the rules differently. So today we're really going to talk about how physicians have to kind of navigate this space very carefully and very differently than the past. I think like what Greg had started off his discussion about the FTC rules and the non-competes, it's pretty evident from that lecture that this space is getting more and more corporatized. So what I intend to cover today, and I'm going to start off with a slight tangent because I think it's extremely important as to physicians understanding it. Number one, I want to really talk about the NPDB. Believe it or not, I've actually stood in front of multiple groups, multiple physician groups, and asked them if they knew what the NPDB is, and some of them could tell me what that NPDB meant, but they could not tell me what it exactly does. And you'd be surprised as to how many physicians don't know much about the NPDB when it's, in my mind, it's just as important as the board of medicine would be to you guys. The next thing we're going to touch upon is the governing documents that affects medical staff privileging. We're going to talk a little bit about the investigations process, and we're going to talk about the disciplinary process that takes place inside hospital systems. And likewise, it takes place in other places too, but primarily we're going to talk about hospitals tonight. That's also my background too, is mostly in the hospital space. And last but not least, we'll talk about what to do if the disciplinary proceedings go wrong. So with that said, let's start off with really market forces. I like to start off with really talking about what I believe to be the undercurrents of this space and how medical staff privileges came about. Number one, it came about as an issue of safety, right? So you put in privileging and all of those thresholds and credentialing things that you have to pass through to really protect patients. And it was all about safety, right? And over time, that's kind of changed, right? Because more and more liability lawsuits started coming up. More and more things started getting reported to the NPDB. And there has also been a shift in payment structures. The dollars are tightening over the years. And, physician morale is low. People are literally having a turf war inside some of these hospitals and healthcare systems. As much as they may deny it, it's true. It exists, and people don't want to. The forces that be don't want to admit to it, but it's there. And I think, and we're going to touch on that in a pretty nice way today, hopefully. By the way, if you have any questions, feel free to type them in, and or simply ask if you like, or you're welcome to interrupt me. I don't mind at all. So first question is, what is the NPDB? It's the National Practitioner Data Bank, right? So beyond that, what do you know about it as a physician? Okay, so let's talk about it. It was intended to help protect the public. And for the most part, it does its job. However, the National Practitioner Data Bank, and I'm speaking as an advocate for physicians, it sometimes goes awry. So who are the entities that can report information to the National Practitioner Data Bank? Typically, it's hospitals, health plans, and licensing board. And tonight we're going to focus on hospitals. So, and what do they actually report to the NPDB? Number one, it's going to be like medical malpractice payments. Anybody whose medical malpractice payments, paid out for medical malpractice, it's going to get reported to the NPDB, and it's going to show up literally kind of like, think of it as your driver's license report, but this is your professional license report. Any ding that you have, any ticket that you have, any payment, fine that you paid, it shows up on your driver's license. In the same way, you have to look at this as your medical license, where the NPDB picks up all of this sort of information, and it all goes towards the risk or the safety of the particular provider whose profile you pull up. Much in the same way, like your driver's license is kind of a profile of how well you drive, how safe of a driver you are. So in that, that's really why it was created. It was really created to like show risk, well, I guess, risky providers that are out there. Now, the other thing that it'll show is the adverse clinical privileges actions that can take place inside hospitals, right? So I'll give you an example. Just the other day, I had a physician call me up and said, "Hey, I got terminated from my employer. Can you help me collect my salary because I was terminated without cause?" So, typically that would be a no-brainer, yes. And so I asked him, who's your employer? And it turned out to be a hospital system. And when he was terminated, he lost his privileges right along with it. So in this particular situation, when he lost his, when he was terminated without cause, they actually did not give him a specific reason as to why he was terminated. And he said, well, I want my money and I want my record cleared up that I was terminated without cause. So he sends me over his letter. I look at it. It doesn't say it was with cause or without cause. So if it doesn't say it was with cause, it's generally kind of a rule of thumb that it's without cause, unless stated otherwise. So when I looked at that, I said, hold on, you've got hospital medical staff privileges. You've got to step into this carefully. You can't go around demanding stuff from a healthcare system, because the next thing is, if you're going to go and demand payment from your former employer, and you're going to tell them that you fired me without cause, they're going to look for ways as to why there was cause. And then you're going to have serious issues, because if you were ever terminated with cause and you're made to resign from your medical staff privileges, you've got issues on your hand, and this is not to be taken lightly. And so now, as more and more physicians become employed, there are more and more of them are going to get into these sorts of situations where they're going to get pushed out of healthcare systems, sometimes legitimately, sometimes not so legitimately. Now, if I believe everything that this particular person called me up about and said that things went awry, yeah, I would believe that it was all without cause. And, so for some reason, he just didn't. I think that there must have been a rub on the inside that somebody didn't like somebody and then they terminated him. That's really what it boiled down to. But believe it or not, physicians can be disliked by their employer. They can be terminated by their employers. And if there is a cause for termination, it equals a level of malfeasance, misfeasance, it can be reported to the NPDB. That's why you've just got to be super careful. And as new physicians enter into this marketplace, into this workforce, they've got to become more and more aware of what the NPDB does. Believe it or not, you can go right to the NPDB website. There's about a 90-page booklet. It is such a nice summary of what the NPDB does and doesn't do. It's just a great read for any physician that's starting off their career. And even if you're mid-career, I suggest that you go and read the NPDB guidelines for physicians. Any questions on this part? Okay. Next, what I want to talk about is what governs medical staff privileges. Well, there is actually medical staff bylaws, and then there's hospital bylaws. Well, what's the difference? What's the difference between medical staff bylaws and hospital bylaws? Well, medical staff bylaws literally govern the medical staff that's there, especially physicians and including nurses. Whereas the hospital bylaws, it really governs the administration of the hospital, which is very different than the medical staff functions of a system. So that's how they're different. But every hospital system has both of these. So just know that exists, and that's kind of how it works. So in my next several slides, I talk about it. about medical staff bylaws and who's responsible for creating them, which is really the medical staff and ratified by the board of directors. It's really a set of bylaws that the medical staff puts together. Inside a hospital, as you probably already know, is that there are employed physicians and then there are non-employed physicians, meaning physicians from the outside who have medical staff privileges. So they all have to abide, whether they're from the inside or the outside, they all have to abide by these medical staff bylaws. Now, the board of directors and the MEC can put together rules and regulations as that apply to the medical staff, but nonetheless, the medical staff bylaws and those sorts of rules are created by the medical staff. On the hospital bylaws, remember it's all done through for purposes of administration. Medical staff does not get a whole lot of say so in the hospital bylaws, but obviously they have the ability to purview and reject some of those things and raise the flags as they need to. Now, when it comes to medical staff privileges, there are multiple different types of medical staff privileges that could be given to a physician. They could have active staff privileges. They could have provisional staff privileges, meaning like a few months a year. They could have like a consulting staff privileges, like you could have medical staff privileges in one hospital, and you could be a consulting staff, have consulting staff privileges in a different one. You could even have honorary staff privileges, whereas sometimes what will happen is if a physician retires, they may get honorary staff privileges to be involved with a hospital going forward because it helps the hospital function better. During COVID, you may have seen disaster staff privileges that were being issued. And also remember, if someone is providing telemedicine services to a hospital, they need telemedicine privileges. You cannot just go and, even though the person may not be inside the hospital, they are providing services to the patients of the hospital, so they would need telemedicine privileges. Now, the committees that the medical staff is regulated by is number one is first and foremost is the medical executive committee. It is the medical staff. It's a governing committee, and it is and it essentially oversees what's going on with the physicians. The president of the MEC is usually a physician. No, sorry, not usually. It must be a physician, and the other officers of the MEC must be enumerated in the bylaws. So, like for example, if the bylaws say that they can have a position of a chair, a vice chair, and so forth, then it's going to be outlined in the bylaws. The other thing is the MEC has the ability to put together committees. They could have a qualifications committee. They could put together a bylaws committee, a peer review committee, and even like a health and wellness committee. They could come up with almost any type of committee you can think of. So a MEC can actually go and appoint these committees, and these committees can actually have subcommittees under them. So just know that that also exists, and it's going to be important for you to, as you go and become employed inside hospital system, it's going to be important for you to know the lay of the land, and that's why I walk you through this whole process. Now, what is involved in the privileging process? So let's talk about that a little bit, because it's not just you submit your application, it goes in and you get, somebody looks at it and it gets approved. Well, let me walk you through the actual steps that are involved. First of all, there is a credentialing application that's filled out. It's got authorization forms on it. Those authorization forms actually have legal releases and waivers that the physician is signing off on, meaning if whatever comes into that hospital's file becomes their property, and now they have the ability to usually disclose it without any further request from the physician to be before they actually disclose it. So you got to understand that when you sign a credentialing application, you're authorizing certain things, and they can work against you, especially if somebody's got a history in the past, warranted or unwarranted, it doesn't really matter. If there's just a history in the person's past, it can actually come up you may be giving access to other people to that history just by signing that authorization form. Now, the next thing that'll happen is step number two, which is the medical staff services personnel will go through and verify each applicant's information. So, like their licensing, education, training, and they will check the NPDB as well. The NPDB plays a critical role in this. Everyone looks at it for multiple reasons, and I'll kind of walk you through those in just a minute as to what's essentially being done in this credentialing phase. But well, actually, let me just touch on it now. What they're really looking for in the credentialing phase is they're looking for character, competence, training, experience, and judgment. And they will do this process every 24 months, or they should be. That's essentially the recommended guidelines for re-credentialing somebody every couple of years in a hospital system. I better speed this up. Okay. So anyway, so first there's a credentialing application. It goes in for verification. Then it goes in front of a department chair. If a department chair ever comes to you and says, "Hey, we're going to deem your application incomplete," ask them why, and don't push for it to be deemed complete, because there may be perfectly good reasons as to why that department chair doesn't think it's going to get approved by the medical staff committee. And if they don't approve it, then it is a reportable condition to the NPDB. So be careful at this step number three, because step number three, if there is a holdup here, and you wanna take a look at it a little bit more closely. So now let's talk about. Well, I think I'm going to skip through the investigations process, because there's an investigation committee that could be started. It basically is on a fact-finding mission, which is usually an investigation committee, and it has the ability to go and recommend actions to the MEC. The MEC can then take the facts that were found by the investigating committee and take no action, issue a letter of reprimand, or suspend. So that's kind of how investigations work. There are generally, and what I want you to get out of this slide is that there's really three things that can happen at the end of an investigation. At the either the MEC will decide to do something about whatever they find, or they will just simply issue some sort of a letter of reprimand and just tell you not to do it again and kind of move on, or they will take no action at all. So those are the three outcomes that happen here. Sorry, I'm kind of also keep in mind that I'm sorry, I'm rushing along, and in doing so, I'm kind of eating some of my words in my head, just not saying it out loud. So sorry about that. So yeah, just remember there is what's called a immediate suspension provision in most medical staff bylaws. That immediate suspension allows for anyone to be suspended for a 14-day period without notice, and it's really intended for investigation purposes. But the only time and place to use it is when that person is deemed to be an imminent danger to the health of any individual or patient that could come before them. So it's got to be an imminent danger, right? So that's when immediate suspensions can be had. Now, keep in mind, there's no real regulatory body out there that says what happens if somebody is suspended for 20 days or 25 days, but there are rules that are out there that say that if someone is suspended for more than 30 days, that it must be reported to the National Practitioner Data Bank. So keep these immediate and emergency suspensions in mind. They are potentially out there, and people will use them. Now, what are the steps in the disciplinary process? I think I've got about 5 more minutes. So there are progressive disciplinary steps that can be taken before anything formal is done. So the MEC or your department head can come to you and say, "Hey, we're going to do some collegial intervention, or we're going to do some very specific sort of education for you, so we can help you get better at something. Because when they do their peer reviews, if they find something wrong with something, for like, let's say a procedure is not being done properly because of XYZ items, they might just decide, what, education might be the best way to overcome that hurdle. They could even say, what, let's get this person some mentoring, where they will have a more experienced physician intervene and kind of become the mentor to that physician who was having issues of whether it's competency or professionalism. They could actually take up any of those issues. The other thing that they can do is put them in counseling or ask them to go to counseling, but they can't force it upon them. And they could even make a second opinion a requirement. Now, as it gets to the level of a second opinion requirement, meaning, so for example, if a physician has hospital staff privileges and they're supposed to remove a gallbladder, if the MEC says you need a second opinion before you perform that gallbladder removal versus after you get a second opinion, if it's there are different ramifications for that, because on one there it's like a higher level of essentially a reprimand, and that can become reportable, believe it or not. If you are required to get a second opinion requirement and a go ahead before you can provide privileges, that's got a different level of ramifications versus after the fact. So, like, let's say in the same scenario, you have a surgeon that performs gallbladder removals, and they get a second, or they get a post surgery review of their files. What'll happen on that sort of a scenario is they're just getting good old mentoring and counseling from their from the person that's reviewing the file. But if they're getting guidance ahead of time, that means that there's something more seriously wrong, and that could have additional ramifications to it. Now, the other things that could be considered is getting a proctor for that physician that's having problems. There can even be anger management, sexual harassment, behavioral management courses. That could be, like a boundaries a course that the physician may have to go through. These are all a part of the progressive disciplinary actions that can take place. Now, there could even be that precautionary suspension that we talked about just a minute ago. And if the suspension continues on, meaning past the 30 days, it's a reportable issue to the NPDB. Now, that can all lead to disciplinary hearing process. And let's talk about that a little bit and how that can begin. Let me ask you this. Any questions about progressive disciplinary actions right now? Like, what are some of the progressive disciplinary actions a hospital system can take? How can they help a physician improve without taking them through the formal ringer of writing them up? Okay, so these slides on page 20 and 21 were really intended to help you understand what are some of the steps involved that a physician that could help with that. Now let's go through the formal due process. So let's say that the MEC decides, hey, we're going to take up this physician and we're going to put them through a formal due process because we want to take some sort of an adverse action against them. The first thing that they have to do is they have to send out what's called a notice of reasons. And it would be a notification that's sent out to the physician, and it has to state with specificity as to what the physician failed to do, what they failed to meet, and under what instances that occurred. When that happens, then it's up to the physician usually to request a hearing. So now keep in mind, they're going to send it to the person's last known address that they have, or they're going to hand deliver it to them, and they could even email it to them. There is no per se way of delivering it. You got to read your medical staff bylaws. That may have in it the method of delivery of that particular notice. So that's your notice of reasons, and that's how the disciplinary formal due process begins. From there on out, a hearing will be had, and the hearing is triggered, and then everybody gets ready to actually have the hearing. And before the hearing, they do what's called pre-discovery, right? So you have the right to go and ask for documents. You have the right to find out, what sort of witnesses are are actually coming out against you. They've got to give you a witness disclosure. You have to give them your witness disclosure, and it's much like a courtroom, except it's done by a hearing panel. And oftentimes in the healthcare system, there will be a hearing officer, which is usually a person like a seasoned attorney that plays the role of a hearing officer. They're not exactly the judge, but there is a hearing panel. Now, on the hearing panel, the people that get to sit on the hearing panel have to be objective. They cannot be people that are employed by the healthcare system. They cannot be people that are your direct competitors. It really has to be a objective outsider, sort of non-interested parties that are on the hearing panel. So a hearing officer also helps make sure of that. So let's say that a physician goes through the notice of reasons, invokes their hearing, goes through the whole discovery process as to finding out what happened in each file, and then they have the hearing itself. And in front of the hearing panel, everybody makes their arguments, and chances are, in one form or another, the hearing panel has got definitely a 50-50, if not a better shot, on deciding against the physician. And that means that things have gone wrong. The hospital will typically be represented by a large law firm. The physician will typically be represented by a small to mid-sized law firm. And this is a pretty hairy process that a physician goes through. It's very trying. It's difficult for the physician as well as the folks on the inside of the hospital system, and it's also difficult on the attorneys that are involved because, again, most of us attorneys, even in the healthcare law space, do not do this process every single day or even multiple times a year. Most of us get involved in it just a few times a year, but usually on the periphery. But to take it to a hearing panel in front of like a whole hearing officer and so forth, it's pretty rare. I don't have that many colleagues that actually do that. But it's neither do I know that many physicians that do it either. But this is obviously the lay of the land that's been put into place that a physician has to get ready for when they go and join a hospital system. So now let's say that there is a adverse decision made by the hearing panel against a physician. What is a physician to do next? So, if the hospital proceeding goes wrong, what should they do? Well, they really have this next option, which is to file a notice of appeal and by filing a lawsuit. But the filing of the lawsuit has to be done within 30 days of the adverse decision. The physician cannot sit on it indefinitely. They've got to really act and react and file something in the local court of law, and really file their lawsuit timely. Otherwise, they are deemed to have waived it. So just make sure that if somebody gets caught up in this whole hearing process, there's an adverse decision against them, that they exhaust all administrative remedies, and then they file a lawsuit, and then through that lawsuit, it will give them another shot at doing discovery, going through a mediation process, and then proceeding to trial. So that's kind of how it works, and this is kind of like the last stage, which would be the Florida court system, where you can take that ultimate hospital medical staff grievance and have the courts listen to it. You can even ask for a trial in front of a jury when this happens. And I think for most of the physicians that I've represented before the court, that works out really well when they have a trial by a jury. Just because the hospitals don't want to go down that road of having laypersons make the decisions of what a hospital did or did not do. There are ways to actually defend against it. I've defended against it in court multiple times, and it's not a fun it's not a fun thing for any physician to go through. And as their legal counsel, you try to do what's right by the physician and try to get them out of this situation as quickly as possible. So anyway, with that said, I'm going to wrap it up here because I think I'm over my time. If you have any questions, you're welcome to text or email me. Here's my cell phone number and my email address.